Hello everyone and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you'll enjoy this legal education content, and today will be the day I earn that subscription. For today's story, we are covering the ongoing, apparently still ongoing, lawsuit between Petito and Laundrie. You will remember that Brian Laundrie killed Gabby Petito. This is bad. However, the parents are now suing each other. This is confusing. The parents, Petito, are suing the parents, Laundrie, for intentional infliction of emotional distress. A legal theory that doesn't really much make sense, because intentional infliction of emotional distress is really hard to win. Really hard. It is a very disfavored cause of action, and it requires pretty outrageous conduct, of which, in my humble opinion, there is not. The judge apparently disagrees with me. This seems to me to be a miscarriage of justice. I have read all the underlying documents in this case thus far. Read the original complaint, read the original response, read the original reply. I watched the hearing. I did all the things. And I disagree vehemently with the judge in this case, that there is a viable cause of action. I believe this is delaying the inevitable, and I believe the judge may be doing this out of reasons of sympathy and empathy rather than law, which maybe goes to show that putting Miss Petito in the front row, crying, maybe was a good decision after all, for strategic reasons, because maybe it got to him. In any case, we're going to cover this decision for the legal merits of it all, and we're going to do this, so let's go ahead and get started with this. So this is in order denying the motion to dismiss. A motion to dismiss, as I'm sure the judge will tell us, we have to assume everything in the complaint is true. We have to assume basically the best possible scenario. And then the question is, can you win on a matter of law? Like, we have to assume everything they say is true. If everything they say is true, can they win? In my opinion, no. They don't have a cause of action. The judge seems to disagree. Okay, let's see why. Before the court is defendant's motion to dismiss the amended complaint. The plaintiffs file a response, and the defense file a reply. Today's ruling does not determine what happened to Gabby Petito. That would be difficult. Instead, today's ruling is technical in nature. I like technical. It only determines whether the parents state a valid claim against the other parents. Now, because Laundrie's statement by their attorney, in the context of the unique facts of this case, is objectively outrageous, yeah, you're going to need to show your work on that one. The court concludes the plaintiffs have stated causes of action for intentional infliction of emotional distress against the Laundries. The court there denies the motion to dismiss. Really? The statement is objectively outrageous. We have a very low standard for objectively outrageous. We have read the case law. It was discussed in the hearing. Objectively outrageous requires a lot. For example, we covered the case of Ford Motor Credit. Ford Motor Credit wanted to collect on a debt. This is a lawful goal. Their methods of collecting the debt left something to be desired. Ford Motor Credit called the mother of the debtor and said, "Hi, I'm from Mercy Hospital. The debtor's children have been in a serious accident, and we're trying to locate the debtor in order to notify them so that, we can help them and stuff." Fast forward an hour later, the debtor gets in contact with the mother and spend the next 7 hours trying to locate their own children before they realize, hey, it wasn't really Mercy Hospital. It was actually Ford Motor Credit the entire time. This is the kind of thing we're looking for in outrageous. Statements that defy all sorts of humanity. Right? The classic example is that you tell a young mother of young children who you absolutely know for an absolute fact their children are in fact okay, but you tell them their children is dead. Ford Motor Credit's pretty close to that, as I just described. So that is the kind of thing we're looking for, not whatever this is. So yeah, let's go ahead and start this, or continue this. All right, the operative complaint is the amended complaint. In each 4 counts, purport to state a cause of action for intentional infliction of emotional distress based on the same allegations of fact. The plaintiffs are the Petitos, the parents of Petito, who is deceased. The defendants are the Laundries, the parents of Laundrie, who is also deceased. Each plaintiff sued each defendant. To avoid confusion, the court refers to the individuals by their first name instead of their last name. Okay, under Florida law, the court must assume all wed-pled facts is true when ruling on a motion to dismiss. This is pretty much true universally. We have to assume everything they say is true. That is because a motion to dismiss tests whether allegations in the amended complaint state one or more legal causes of action against defendant. Yes, assuming everything they say is true, can they win? Another rule the court must follow in deciding the motion is the court may only consider facts alleged in the complaint and nothing else, as the motion is not a substitute for summary judgment. I don't think that's quite true, but okay, you do you. The reader's caution: the allegations of fact the court will consider are simply that, allegations not proven fact. We don't know any of these things to be true, we're just going to assume them. All right, so here's what we're assuming. In July of 2020, Brian and Gabby became engaged to each other. The following year, in July 2021, Brian and Gabby left New York, and Gabby's van headed west for a van life trip that was supposed to last several months. Gabby intended on documenting the trip and publishing her journey on various social media to establish herself as a travel influencer. Gabby regularly called her family while on the trip. Gabby's last communication with her father occurred on August 21st of 2021. Gabby's last communication with her mother occurred on August 27th, 2021. Brian murdered Gabby on August 27th, 2021. Brian then texted between his and Gabby's telephone to hide the fact that Gabby was dead. Brian would then continue to send texts from Gabby's phone until at least August the 30th, in which Brian disguised Gabby's mother, stating there was no service in Yosemite. Brian did this to suggest that Gabby was still alive. Gabby was 22 years old at the time of his death. So Brian sending false text messages to the mother, that might be outrageous, but he's dead. On August the 28th, Brian told the parents that he murdered Gabby, which we again are assuming. The same day, Christopher and Roberta spoke with an attorney, and they would send the attorney a money retainer several days later. On September the 1st, 2021, Brian returned to his parents' home in Northport, Florida, driving the van. Brian and his parents then vacationed together at Fort DeSoto Park on September 6th and 7th of 2021. They took this vacation each knowing that Gabby was dead, and the parents were frantically looking for her. Okay, sure. On or about September the 10th, 2021, Roberta blocked Nicole on Roberta's cell phone on Facebook. Fine. On September the 14th of 2021, and fully knowing Gabby was dead, and not knowing the general whereabouts of the body, the Laundries attorney released the following statement. Apparently this statement is going to be the basis for which we're going to file a cause of action, so we'll give that a try. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope the search for Miss Petito is successful and that Miss Petito is reunited with her family. This apparently is the objectively outrageous statement. This is the statement that apparently is objectively outrageous. Okay. On September 16th of 2021, the attorney for Gabby family issued a letter to Christopher and Roberta, which provide the following. So this is now the Petitos talking to the Laundries. We're writing this letter to ask for your help in finding our beautiful daughter. We understand you're going through a difficult time and your instinct is to protect your son is strong. We ask you to put yourselves in our shoes. We haven't been able to sleep or eat, or our lives are falling apart. So they ask themselves to put themselves in their shoes, but abandon their own shoes, right? They even acknowledge their own shoes. We understand your instinct is strong, but forget all that and put yourself in our shoes. But why not your shoes? Why are their shoes not less valid? Why is their instinct to protect their own son less valid than your desire for the safe return of your daughter? Why is that desire less valid? Why is their desire to protect and care for their son less valid than your desire to care for and want to be reunited with your own daughter? Why is that concern less valid? Why should it be pushed aside? We don't know, apparently. We believe you know the location of where Brian left Gabby. We beg you to tell us. But would you do it if it were the other way around? Are you sure? As a parent, how could you let us go through this pain and not help us? Well, you kind of acknowledged that actually already in the early introduction. Remember, how could you do this? You already said the answer. Your instinct to protect your son is strong. You know the answer to the question. You already said the answer to the question. Your instinct is to protect your son. He's your son. Your instinct is to protect him. How could you do this? Because we're trying to protect our son. The instinct that you said you recognized. Okay. As a parent, how can you put Gabby's younger brothers and sisters through this? See above. Gabby lived with you for a year. Yes, the son lived with us even longer. She was going to be your daughter-in-law. He was, in fact, our son. How can you keep her locations hidden? I'm trying to protect his interests. You were both at Jim and Nicole's house. He was at our house. You were both so happy that Brian and Gabby got engaged and planning to spend their lives together. Please, if you or your family have any decency left, please tell us where Gabby's located. If they have decency left, that decency apparently includes wanting to protect their own son by their own terms. It's right in their own letter. They say it. We understand you're going through a difficult time and your instinct to protect your son is strong. Is that not a decent thing to do? To want to protect your son? If you have any decency left, please tell us where Gabby's located. How about the decency for your own son? How about that decency? Apparently that decency is less important somehow. Because their son is a murderer? That doesn't make any sense. Or maybe it does to you. So their desire, my parents always told me that their love for me was unconditional. Maybe you think that love should be conditional. I don't know. Maybe you think the parents' love for their own son should be a conditional love and not an unconditional love, as my parents always told me that their love for me was unconditional. Maybe you think that the Brian Laundrie's love should be conditional, and maybe you think that they shouldn't want to love, protect, and care for their son anymore because he's a murderer. Maybe you think that it shouldn't go that far, and there are limits to love and desire to protect and care for your own youth or your own children. Maybe you think there are limits. I don't know. I kind of think that, my parents always told me it was unlimited, and that's kind of what I thought. But maybe you believe something different. I don't know. All we want is Gabby to come home. Please help us make that happen. At the expense of your own child, incidentally. Yeah. Christopher and Roberta declined to respond, instructing all communication be made through their attorney. Their attorney would issue no comment when asked about Gabby. They did this knowing that Joseph and Nicole's mental suffering, and by advising where Gabby was, they could prevent such additional suffering and anguish. They didn't have to. My parents always told me I'd have to face the consequences for my action. He was also an adult. Okay, so apparently your values are different than my values. Apparently, the unconditional love for one's own child should stop at some combination of when they become a murderer, when they become an adult, when they do something. So apparently a parent's own instinct to protect for, care for, guard, want to protect their child against the world. Apparently, in your view, these instincts should stop at some combination of when they become a murderer and or when they become an adult. I don't know. My parents always taught me that they love me no matter what. No matter what I understood to mean, no matter what. But apparently you think that the values to protect your own child should stop at some point. Okay, we just have different values then. So be it. Parents sue for Laundries for intentional infliction of emotional distress. The question today is whether the plaintiffs state a cause of action for that tort. Laying aside for the moment the statements the Laundries made through their attorneys, the other conduct plaintiffs complain about mostly involves the Laundries failing to act. Specifically, plaintiffs seek to fault the Laundries for not telling the plaintiffs that Gabby was dead or where the body was located. The Laundries frame their silence in constitutional terms, arguing their silence was constitutionally protected on the First, Fifth, and Sixth Amendments to the Constitution, and related Florida Constitution. The court does not believe it's necessary or appropriate in this case to resolve these matters on a motion to dismiss. The contours of the fact are not sufficiently distilled to apply these important guarantees, are they not? Those claims are more appropriately addressed, if at all, in the summary judgment stage. I don't know. I feel like we can address them now, to be honest. Yeah. My comments are so off normal views. Okay, well, fair. I mean, if you really think my comments are off normal views, so be it. I'm just here to express my views. If you disagree with my views, then fair enough. My parents told me they loved me unconditionally. I understood the word unconditional as to mean without condition. That's what I understood it to mean. I understood that they would love me no matter what. In fact, I talked to them recently, and they still say that they love me, even though I'm very much an adult. I understood that they loved me, and they wanted to protect me, and they would help me, and they would guard me, and they would provide for me no matter what. They say that even still, that they want that. So, okay, then we just have different values. You apparently are of the view that you should, at some point, stop protecting and caring for your own children. At some point, you should stop wanting to protect them and guard them and wanting to provide for them. At some point, your love should stop, and you should be willing to just treat them as a stranger to you and that they're on their own. If that is your values, so be it. It's not my values. So I don't know what to tell you except we just disagree. Plaintiffs have, during oral argument, candidly concede they have struggled with legal duty owed to Laundries to break their silence. Plaintiffs appear to conflate morality with legal duty. Also, the morality, at least to me, is not clear because they themselves acknowledge a morality towards their own son. They think the morality to their own daughter should supersede that morality, but then again, they're a little bit biased by the morality to their own daughter, as they kind of should be. But it's like, yeah, okay. Yeah. But would your parents protect you from the law if there was compelling evidence you committed a serious crime? I don't know. They told me they'd love me no matter what. I understood no matter what to mean no matter what. I understood unconditional to mean without condition. I mean, that's literally what the word means. I'm not sure there's a lot of ambiguity in unconditional. Also, as an attorney, I would tell anyone I would tell a complete stranger if they asked me. I would tell a complete stranger if they asked me to keep their mouth shut. I've told you that, guys, many times before. Like, keep your mouth shut. I want a lawyer. I want to remain silent. I've told you many, many times that you should keep your mouth shut in order to protect your own interests. This is unconditional advice. This is unconditional advice because I know that if you don't do that, you are going to have a bad time because we've seen it happen many, many times. I don't know how good an attorney I would be if I gave you any advice other than that. Oh, if it's a really serious crime, if you murder someone, you shouldn't use your right to remain silent. You should definitely talk to the police. I'm not sure how good an attorney I would be if I gave that advice instead of giving it absolute of you should keep silent for your own interests. And why would I give my own child different advice than I'd give a complete stranger on the internet? This seems like a strange proposition, right? If I'm going to give a complete stranger the advice on the internet, hey, you should remain silent no matter what because your words can be used against you and you probably shouldn't confess to the murder and stuff because that's not going to go well. No matter what, no matter how bad your crime is, you probably should keep your mouth shut. If I'm going to give this advice to the internet, to a complete stranger, why would I give any different advice to my own child? How can I possibly be a bad person for giving that advice when it's the correct advice? Unless you think it's the incorrect advice, in which case we have to have a whole discussion. You know? Like, okay. Okay. If the facts of this case were truly about a silence with no affirmative duty to act by the Laundries, the court would have resolved this case in Laundrie's favor on the concept of legal duty, or more precisely, the lack of legal duty. Had the Laundries truly stayed silent, the court would have granted the motion to dismiss in their favor, but they did not stay silent. Okay. The Laundries' attorney released a statement plaintiffs argue was outrageous under the facts of this case. Was it, though? Plaintiffs sufficiently alleged Laundrie spoke. Christopher Laundrie and Roberta Laundrie, through their lawyer, issued the following statement. At oral argument, the Laundries contended there was no allegation in the complaint that their attorney knew that Gabby was dead or the whereabouts of the body when he released the statement. That position is meritless for at least 3 reasons. Generally, an attorney serves as an agent for the client. The attorney's acts are the acts of the principal, that is the client. Second, all facts and reasonable inferences are construed in favor of the non-movement. Here are the parties. A reasonable inference is the attorneys knew the same information the Laundries knew. Third, the words used in the statement indicate the Laundries agreed to it. It's provided our understanding on behalf of the Laundries family. It's our hope. Certainly, there's no allegation the Laundries disavowed the statement. For the purpose of the motion dismissed, they must assume the Laundries are responsible, which I have no problem particularly assuming that for the motion dismissed. I just don't think it particularly gets anywhere, in my opinion. Let me take a quick look at chat and see what's going on over there. Okay. The Laundries contend that their statement is not outrageous as a matter of law. It's not. At oral argument, they suggest it was merely a plain statement. Plaintiffs, in contrast, countered during oral argument. The statement was knowingly false, designed to create false hope, and issued by the Laundries, who knew Gabby was dead and where her body was located. The elements of intentional infliction of emotional distress tort and the contours of that tort have been described by the Second District Court of Appeals. To state a cause of action for intentional infliction of emotional distress, a complaint must allege 4 elements: deliberate or reckless intention infliction of mental suffering. No. Outrageous conduct. No. The conduct caused the emotional distress. No. And the distress was severe. No. They didn't do any of those things. The distress was from the missing of the child, not from anything the Laundries did or didn't do. Behavior claimed to constitute intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. In applying that standard, the subjective response of the person who's the target of the conduct does not control the question. Rather, the court must evaluate the conduct as objectively as possible to determine whether it's atrocious and utterly intolerable in civilized community. In my humble opinion, this statement doesn't come anywhere even remotely close to any of this. Where conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not of fact. It is a question of law, not of fact. Right? I don't need to know what the facts are, because it's a question of law about what it allows for. Is the possible bounds of this exist a priori of the facts, kind of like every legal theory exists a priori of the facts. And then we have to figure out whether or not the facts fit the legal theory, not the other way around. And so I don't have to necessarily know the facts to know what the bounds of this are. And this, even with these facts, it's not outside those bounds. It doesn't make any sense. The court focuses on the second element, outrageous conduct. Both sides present several cases the court has reviewed suggesting the conduct alleged in this case either was or was not outrageous. It's not even close to outrageous. Reviewing those cases was helpful to calibrate whether the alleged conduct was outrageous enough to state a cause of action. This court is full of shit. An important lesson from the cases cited by the parents is that context matters. Conduct viewed in isolation as being insufficient to state a cause of action, when considered with other conduct, may be sufficient to state a cause of action. In Stedman, the Second District Court concluded that insurance companies' delay in approving a double lung transplant after having been ordered to do so by a judge of compensation claims by itself did not arise to outrageous conduct, but when paired with other conduct, such as knowledge the delay would speed up the demise of the insured, the delay in approval rose to outrageous conduct. Yeah. Super Chat says, if they knew she was dead, but still openly wished for her to be found safe, wouldn't that be open up to wasting police resources? Technically speaking, they didn't say that she hoped that she'd be found safe. Incidentally, the statement was very carefully worded. You might have read in the word safe, but it didn't actually say that. Anyways, the Florida Supreme Court, in recognizing the tort of intentional infliction of emotional distress, suggests the comments to Rule 46, Statement of Torts, may cabin the contours of the tort. Regardless of whether the conduct might fall outside of the comments to be considered outrageous, the Laundrie's conduct here does find support of a comment, and of F. Comment F says the extreme and outrageous character of the conduct may arise from the actor's knowledge the other is particularly susceptible to emotional distress by reason of some physical or mental condition or particularity. The conduct may become heartless, flagrant, and outrageous when an actor proceeds in the face of such knowledge, were it not been done so if the actor did not know. When you're intentionally in trying to inflict distress, yes, your knowledge that the person is susceptible may be relevant. Okay, I buy that, but this, yeah. It must be emphasized again that major outrage is essential to the tort, and the mere fact the other knows the other will regard the conduct as insulting or will have their feelings hurt is not enough. The words used by the Laundries on the surface initially do not suggest outrage. On behalf of the Laundries family, it is our hope the search for Miss Petito is successful, and Miss Petito is reunited with her family. Please take note, it doesn't say safely or alive. When juxtaposed with other conduct in this case, though, the outrageous threshold is surpassed. No, it's not. You're a bad court. As alleged by a plaintiff, the Laundries made their statements knowing Gabby was dead. knowing the location of her body and knowing the parents were frantically looking. If this is true, the Laundrie statement was particularly callous and cruel, and sufficiently outrageous to state claims for intentional infliction of emotional distress. You are full of shit, court. There is no way that this arises to that level. That seems incredibly unsustainable. The court identifies 2 additional cases that support the court's decision, although neither was necessary. Consistent with comment F, the court notes that Florida law recognizes family members are particularly susceptible to emotional distress around the time of the loved one's death, although at the time they didn't know that it was dead, so it doesn't quite work. Malicious conduct during that time frame can rise to a level of outrage. In Thomas versus Hospital Board, medical personnel agreed to tell the family of the decedent died from stress of surgery, and not by negligent overdose during the surgery. At this point, the family knows the decedent is dead. So that's a factor worth mentioning. During the funeral, the medical examiner learned of the coverage, prompting the medical examiner to demand the return of the body for a more complete autopsy. The second district concluded the defendant's action of providing false information to family members under those circumstances met the standard for claim of outrage. The district cited this. Also, incidentally, while I'm at it, and giving legal advice that apparently is contrary to the vast majority of opinion, I would just take note that the vast overwhelming majority of defendants, of juvenile defendants, who wind up in serious trouble is because the parents not only didn't go to bat for them, but openly encouraged them to cooperate with the police. The amount of parents out there who have gone into interrogation rooms and acted as advocates for the police truly is a thing that to behold. And the parents are just like, cooperate with the police, cooperate with the authorities. The amount of parents who regret giving that advice and wish they could take it back is quite notable. The number of parents who have gone into interrogation rooms and said, just be honest with the police. Tell them what they want to know. Tell them what they want to hear. Waive your rights. And then the kid winds up in prison, sometimes for years, sometimes forever. And the parents now have to regret every decision they ever made. I'm just saying. A lot of your instincts that are out there, apparently, the chat's instincts collectively apparently suck. Because the chat's instincts apparently collectively is that these parents should have betrayed their own child. They should have turned him in. They should have told him to cooperate with the police. They should have told him to waive all of his rights. They should have openly confessed the whole thing to the Petitos. The amount of parents who have agreed with you and now regret their decisions is legendary. I would caution you to think real carefully about the advice you might want to give your own kids if you're ever in such a situation, because your future child's defense lawyer is going to hate you, and you're going to hate them, and there's going to be nothing anyone can do about it. Facts. In Williams versus City of Marilotta, police officers took photographs and video during the autopsy and displayed those images to police department at a party. To non-department personnel at a party. The family members were not present. The Fifth Circuit concluded even though the images were a public record, the mayor displayed without public request, even when the family members were not present, was sufficient to create a cause of action. This is probably incorrect, but, whatever. The Laundries argue that denying their motion to dismiss will result in an avalanche of litigation for situations in which relative of tort victims receive bad news about family members. In MM, the tortfeasor told the parents of the victim the tortfeasor had abused the daughter and the wife had supplied illegal drugs to the daughter. The parents then sued the tortfeasor based solely on the distress of the disclosure to them. The daughter separately sued the tortfeasor based on the tortfeasor's abuse. The third district held the parents had no cause of action on these facts. The court remarked that receiving bad news about a family member was insufficient to state a claim when there's no attendant conduct directed towards them. I'm not quite sure how that case is not IIAID. In this case, somehow is. The court has no quarrel with that holding. I'm not sure that that's true. And in fact, it's consistent with this court's decision today. I don't think it is. The facts of MM are simply distinguishable because there's no facts in MM suggesting the tortfeasor directed any conduct toward the parents. Here, plaintiffs allege the Laundries issued a public statement of false hope, knowing Gabby was dead and the location of the body, frankly searching for it under mysterious circumstances. The two scenarios are distinguishable. There will be no avalanche of litigation. The court is well aware the Laundries have made additional arguments in their filing and an oral argument to support their motion. The court need not detail those except to say none are sufficient to preclude the court this motion to dismiss the stage from concluding the stage of action, and therefore it's denied. This is just a bad decision. This is a legally bad decision. It is completely bad. So I disagree with this completely. I disagree with the court's reasoning completely. I disagree that this statement is sufficiently outrageous. I disagree that this is in the same category as the doctors telling the decedent's family that they died from cause A, knowing that it's not true. And then, by the way, a week later, we need the body back for a different autopsy. You know, I disagree with that completely. So, yeah. I disagree with that completely. And yeah. I disagree with that completely. And I think the Laundries did everything right. I think they did everything right getting a lawyer. Their lawyer might have screwed up. I think they did everything right in trying to get their son a lawyer. I think to the extent that they tried to protect him within the bounds of the law, they did everything correct. They did everything I would tell you to do as a lawyer. If you came into my office, if I'm a lawyer and you come into my office and be like, hey, I just murdered somebody, what should I do? Right? The Laundries are doing exactly what I would do. And you're a stranger to me. I would tell you to shut the hell up. Don't talk to the police. Don't make any statements. Just say lawyer a lot. Right? Oh, I just murdered someone. I murdered my fiance in their sleep. I strangled her with my bare hands. What should I do? Shut the hell up. If me giving that advice to a complete stranger is ethical, which I'd like to think it is, otherwise we have a real problem and we need to reconsider the entire concept of the Fifth Amendment, I guess. Because is the complete stranger keeping their mouth shut ethical? I mean, the murder itself wasn't very ethical, but that's over now. So they'd like to leave an ethical life going forward. Is their keeping their mouth shut ethical? Is me giving the advice ethical? If it's giving to a complete stranger is ethical, how is it giving it to my own child any less ethical? How's it me? Oh, I just murdered someone. Oh, I know them. The person you just murdered. You should keep your mouth shut. Is that unethical advice for me to give? It would be unethical for the other way. Like, oh, I know them. Oh, you should talk to the police because I don't like the fact you murdered them. That'd be unethical. I mean, so I don't quite understand. The hatred at the Laundries and what they did. They did everything every lawyer ever says ever. Is that not ethical advice? I tell you guys to invoke your right to a lawyer every single time. Is that not ethical advice? I don't know. So, yeah. Yeah. Laws and ethics are separate? Well, that's why I'm asking. Is it not ethical advice? Is it unethical? That's why I'm asking. I'm asking an ethics question. Is it unethical for the murderer to keep their mouth shut? Is that unethical? Is that an unethical decision for the murderer to keep their mouth shut? If it is unethical for the murderer to keep their mouth shut, is it unethical for the arsonist, for the robber, for the thief, for the trespasser, for the insert blank here? Is that unethical for them to keep their mouth shut? Is silence unethical? Is it unethical? Is it ethical at some points, unethical at others? It's like, what is the ethics on keeping your mouth shut? Is that unethical? Everyone should openly confess all the time. Not confessing is unethical? Or is it only sometimes unethical? At which points? Why? It's like, I don't quite get it. If my son comes to me and says, hey, I committed a crime, is me telling him to keep my mouth shut ethical? Does it depend on the crime that they've committed? Whether or not my advice to keep their mouth shut is ethical? If my son says, oh, I committed a crime, say, oh, what is it? Oh, I was driving, and I skidded off the road, and I hit a mailbox, and I left the scene of a crime. I was like, oh, you shouldn't tell anybody. You should keep your mouth shut. Is that ethical advice? Does it become unethical at some point, depending on the nature of the crime? What are the factors that make it ethical? What are the factors that make it unethical? At what points are it ethical? At what points are it unethical? I'm asking ethical questions at this point, as long as we're asking ethical questions. You know? At this point, Kurt's videos are just rants. I worry he may have mental health issues. I'm just engaging with the chat. The chat and I are having a discussion. The chat are raising questions, and they're raising counters, and I'm giving my perspective. Right? The chat is challenging me. I'm challenging them back. This is a dialogue. They're texting, I'm talking. I'm not taking this personally. We're having a discussion. The chat is making some points. I'm responding with points. I'm making an argument. They're making an argument. So I'm asking questions in the argument. I'm not taking it personally. We're just having a discussion. I have a point of view I'm going to defend. This is my perspective. This is what I think. When I'm challenged, I'm going to provide my answers for my challenge. It's like, okay, you've challenged me. Let me challenge you back. Here are some questions for you to consider. As you're challenging me, here are some questions for you to consider back. That's what dialogue is it not? It's like, okay, the fact that I have a strong opinion doesn't make it any less a dialogue. It's like, I'm just engaging with the chat in respectful discussion, I think. Is that not good? I guess I could completely ignore the chat and just give monologues all the time, but sometimes I like to talk with the chat and see what they have to say. It's not, I'm not mad. I'm not angry. I'm not taking it personally. It's just like the chat seems to disagree with me. The chat, there's a lot of people who seem to disagree with me. There's a lot of people who seem to think that this is unethical. And I'm like, well, okay, let's explore. Let's explore. Let's consider whether it's unethical or not. Let's consider the proposition. Here are some things to consider. And just putting forward some thoughts. Seems like a good thing to do. I don't know. Yeah. And of course, it's completely different from Petito's side. So like, I'm not saying that Petito's feelings aren't right. I mean, if I were Petito, I'd want to feel the same way. I'd feel the same way. If it were my daughter or my son who was lost and missing and someone had information, not only would I want to give it to me, but if they didn't, I'd probably kidnap them and torture them until they gave it to me, which isn't exactly legal or probably ethical, but it's very understandable for a parent, right? If it was my kid who's lost or in danger or scared or something, and I can possibly do something about it, not only do I want you to talk, but if you don't, I'm probably going to kidnap you and torture you until you tell me exactly what I want to know, because I want to protect my kid, and that's what it would take to protect my kid in that situation. So I totally understand the Petito's point of view. I get it. I just I think from Laundrie's point of view, it makes equal logical sense why they're doing the things they're doing. And it's an ethical posture why they're doing the things they're doing. So I don't know. Seems like the thing to do. So I get it. Yeah, I get hung up on the argument when I think about if my baby girl was missing. Oh yeah, no, I'm totally with you. If it's my baby girl that's missing, the Fifth Amendment is the least of my considerations. Also, the Eighth Amendment, dealing with cruel and unusual punishment, is very much at the end of my considerations. Yeah, I know. If it's my child, my desire to cause pain to the world, if my child is in pain, my desire to cause pain to the world to make my child's pain stop is a pretty natural instinct and easy to understand. So I get it. I totally get it. Totally get it. Torture doesn't generate truth. It might not, but it might make me feel marginally better. I don't know. Well, maybe it generates truth, maybe not. I guess we're going to find out the hard way. All right, well, we'll find out one way or another whether or not it generates truth. The instinct is understandable. The impulse is understandable. What the productivity of the impulse is a whole other set of problems. You know? Leslie says, I want to sit in an ethics class taught by you. It'd be interesting. Yeah, sure. We can consider multiple different perspectives. That's fine. I think now that he can't be prosecuted, they need to tell the whole truth. Oh, their criminal exposure isn't necessarily a gimme. He might not be able to be prosecuted, but they can. Maybe. They may very well be accessories after the fact, depending on what you believe. So he might not be able to be prosecuted, but they have criminal exposure. Possibly. So now they have to worry about their own criminal exposure. So I tell them to shut the hell up for that reason. Yeah. Why bother telling your children when they've done something wrong? So hopefully they won't do it wrong anymore. But me wanting to cast them to the wolves isn't like necessarily the right answer. Yeah. Well, if they took a deal, well, if you offer them immunity, then sure, fine. That'd be fine. Yeah. I'm going to sign off for now because I think that this discussion has reached its limits. I don't think that this is a good decision. I think it is untenable. I do not think that this compromises intentional infliction of emotional distress. I think the judge has compromised their judicial reasoning. And I think maybe themselves extending some false hope. Because this still could be dismissed at a motion for summary judgment. But now we have to have discovery, and now we have to have a fight over discovery, and now the Laundries are going to refuse a whole bunch of discovery because they have potential criminal exposure, so you're going to sit them down, and they're going to plead the fifth a lot, and you're not going to be able to get what you want from them either. And so we're going to have whole discovery fights, and it's just, and even somehow if we get past that, it would be reversed by the Court of Appeals, I would imagine. It's not sustainable as a matter of law, in my humble opinion. So I'm going to sign off for now. If you've enjoyed this stream where we've had a discussion, let me know. And make sure to leave your own thoughts and leave your own questions and stuff, because I've at least enjoyed our discussion. I hope you have too. And I hope I've been able to make you think as you've been challenging me. I like being challenged on stuff. And I hope that I've made you think by asking questions back, which is very Socratic, right? It's very Socratic. I ask questions in order to teach. It's like, so here's some questions, right? So I hope you enjoyed it, because I enjoyed it. I had a fun time. And if you'd like to see more of that kind of thing in the future, let me know. In the alternative, if you'd like me not to engage so much with the chat and just give more of my thoughts without the engagement, let me know. We can do that too. We might be on later to do some more stuff. That'll bring us all for now. Until later, my friends, I hope all is well. Cheers and goodbye.